faster process. And I shouldn't say just property. Usually typical civil cases are for money damages. But here, Replevin, you're looking for the return of a specific piece of property. So in this case, we're able to use the property status of animals to our benefit. Replevin cases can take only weeks to obtain a judgment. And for dog owners, Replevin is common, though lesser known, as far as civil remedies. And it does take advantage of that property status of animals. Now, besides these basic issues, know that this is involving non-marital couples. So when you're dealing with a marital couple that's disputing who gets the dog in a divorce, that is a different situation. That's involved in the divorce courts. So it's not something the Replevin courts are going to necessarily handle. This is involving usually relationships or people that, maybe have obtained a dog together and now they're arguing over who gets the dog once the relationship has dissolved. It can also arise in family situations, whether a mother, a daughter, the other family members are disputing who owns a particular animal. It can also come up if someone's animal has been wrongfully taken and they're trying to get that animal back. So there are a number of situations where Replevin does arise in the courts. And it typically takes place in one of two ways. By seeking immediate possession of the disputed property or by seeking a hearing to adjudicate the final rights of the parties. Now, if immediate possession is sought, a bond of usually double the value of the property must be posted to protect the defending party against a wrongful action. And this gets a bit tricky too, because in Replevin, if you're arguing over the value of a dog, if you are representing the plaintiff trying to get their dog back, and they tell you their dog is worth $1 million to them, that may well be true. But if they don't have the $2 million to post as a bond, it could be a problem. So this is where realistic numbers usually come in, and people will try to at least set the bond at a reasonable rate so that they can post double bond if necessary and if that's what the court and their jurisdiction requires. And that's not to say their animal isn't worth that much to them, but the realities of how Replevin courts work would make it very difficult to actually post a bond of a very high value. Now, where the rights of the party claiming true ownership could be harmed by alerting the other party, in possession of the disputed property, a judge may issue a Replevin without notice. There, when the disputed property is a dog, this means that the judge will order a sheriff to enter the home of the party accused of wrongfully withholding the dog without first notifying him or her to return the dog to the party claiming true ownership. Now, when someone is establishing ownership, they're going to, or even seeking to have a Replevin enforced, they're going to need a few items. One is obviously the purchase or adoption papers showing that they are the true and rightful owner. Another way is through veterinary records, microchip registration, city and county licensing, proof of living arrangements or other care provided. All of these are things that really should be obtained prior to bringing a Replevin suit to make sure that a reasonable argument can be made to the court that the plaintiff is the true and correct owner. Similarly, if you're on the defense side, these are all things that will be used to show that no, the plaintiff is not the true and correct owner. Whether or not to proceed with or without notice of a Replevin is going to depend on the specific circumstances, because as noted just a moment ago, requesting a hearing, you're requesting in a without notice situation. It's an ex parte hearing where a bond is going to be required, and it'll be important to note that for a court to issue such a drastic remedy of a Replevin without notice, there needs to be some concern that something would happen to that dog were the dog not to be turned over to the owner claiming, or the person claiming true ownership and claiming the right to possession. For example, destruction or concealment of the disputed property. If someone has threatened to harm the dog, that would be a reason to go for Replevin without notice. If they're threatening to remove the dog from the state, if they're moving to somewhere, California, and you live in Illinois, that would be a reason for replevin without notice. Harm resulting from the perishable nature of the disputed property. Of course, in a situation with a dog, if someone is neglecting the animal, that would be a reason. Sale or transfer of the disputed property to another. If the other party is threatening to sell or give the animal to someone else, that would be a good reason for replevin without notice. Or if the disputed property, here a dog, was obtained by theft. And that, again, a reason for replevin without notice. All of these are to protect the particular or the specific property here, the dog. Also, know that if a person is seeking replevin without notice, they will have to provide a sworn affidavit for the court or testimony. And that is, in fact, to protect the person on the other side. Because, as we all know, there can be wrongful claims for replevin. But also know that even if the person is successful in obtaining a possession through a replevin without notice of the dog, the ultimate ownership rights will be determined at a hearing or a trial. There, the rightful owner must present the proof of ownership, such as found in the adoption records and microchip records and licensing that we discussed a moment ago. But also, they must show that none of the exceptions would apply. And these exceptions would include if the animal was abandoned, if there was a co-ownership contract, or other contract which would have relinquished some of their rights. And I mentioned relinquishment too, because in some situations shelters have been accused of wrongfully withholding a dog when in fact the actual true owner had relinquished that dog to the shelter. Gifting is another area of contention, because in a replevin, it is entirely possible that an argument by the defendant could be that no, while these people may have lived together as a couple, one member of the couple gifted that animal to the other. And that has in fact come up and it has been addressed in trial court cases and on appeal. And so a gift will negate a replevin claim. Now, in other situations, or some situations where a writ of replevin would result in unjust enrichment, or where the case involves fraud, a court may deny replevin to the requesting party. And this could occur when an owner is named on the purchase or adoption papers, but they contributed nothing to payment, training, care, or veterinary needs of the animal in question. Also, a party seeking replevin in such circumstances should include an additional claim for unjust enrichment. Also, fraud in the inducement has been alleged where one party contributed to the purchase or adoption fee, but was then told that he or she had not been named as an owner to the companion animal, was told that they had been named as an owner, but were never in fact, named or included on any of the paperwork. So in those situations, fraud in the inducement may in fact arise in the courts. But where it appears more commonly, where it appears that both parties have contributed equally, or both are named on relevant paperwork, the courts will often encourage the parties to settle or agree to share custody, but understand that the feasibility of such an agreement may not be appealing to your client. For example, if someone is breaking up, they may wish to enter new relationships unencumbered by having a situation where they have agreed to share custody. And while it may be a different situation in divorces, which we won't cover here, but if a party willingly enters into a contract where they would share such custody, the courts may enforce it based on the parties' agreement. However, it may not be reasonable, especially if the parties are young, and if the animal, if they may move with the animal to another state, a shared custody agreement may not work very well in the long run. So alternatively, one party may agree to pay a sum of money to the party who's no longer in possession of the companion animal, and that is most likely what occurs in situations where the parties simply cannot agree and yet have been co-owners of this animal.